Okay, why don't we start? A few others may join, but I really wanted to welcome our guest, Professor Gruber, who joins us from University of Colorado to talk to us about a really, really remarkable and exciting, not totally new book. I guess it came out around this time last year, but it's a fresh topic. It's very much a pressing topic still. It's called The Feminist War on Crime. To introduce you a little bit to Professor Gruber, she's been doing work looking at our criminal system and also looking at the unexpected role of feminism in our punitive practices for some time. There's a wonderful, 2007 article where we were looking at the shift in approaches towards domestic violence and the carceral turn in domestic violence enforcement. Professor Gruber is a member of the American Law Institute, and these topics are a pressing issue in the area of the ALI Model Penal Code Sexual Assault Project. These connections between feminism and criminal law and procedure and critical theory are that her work is really at the center of are incredibly important issues. They're a year after the book came out, they're really important issues because we're hearing all kinds of talk about what to do about the rise in domestic violence during the pandemic. And these same debates are really important ones. In addition to writing really impressive top scholarship and crystallizing some of that scholarship in this great new book, Professor Gruber is also a frequent commentator on different news channels and the New Yorker and the New York Times. As you will see, if you haven't read the book already, you should get a copy. We wish we could be doing a signing today, but Professor Gruber does just a really good job of crystallizing issues in a way that non-lawyers find accessible, and some of us lawyers find really accessible and appreciate as well. So our plan today is to have her, give us a tour of the book for about half an hour. But we encourage you to post your questions. And we'll be reminding you to post your questions so that we can have a great Q&A. We'll also post information about how to get the book and about signing up for our Wilson Center mailing list if you want to come to future events. And so this is by the way our last Novel Justice event of the spring, and it could not be a more perfect way to end our season talking about criminal justice books, talking about the feminist war on crime. Thank you so much for joining us, and please take it away.
Well, thank you so much, Brandon. It is amazing to be here with Professor Garrett, whose work, is such an inspiration to me and so many others, lying at the intersection of scholarship and policy reform and making practical differences in people's lives. And your dean, Professor Abrams, some of her historical work on sex work, Asian sex work, which is something that has been also in the news a lot. And I actually just have an Al Jazeera op-ed out on kind of the connection between, racism and the carceral state and the way that, like Asian spa workers have always been demonized. But your dean, Professor Abrams' work in this area really was something that I relied so heavily on in the book. So I've been meaning to tell her that I owe her really a great debt of gratitude for that. So I start out the book. Oh, and let me say just thank you all for being here. I know it's getting to that time of the semester, and it's been that time in the pandemic. So that anybody can come and spend a little time talking about my book. It's just really a treat. So thank you. So I start out the book talking about being a law student, being an aspiring attorney, and feeling mired in this feminist defense attorney dilemma. That's what I call it in the book. So, I was one of those people who interned at the public defender at 15. I believed in the mission of representing indigent people facing incarceration. But I had always presumed, just through undergrad and law school, that feminism meant fighting domestic violence and rape, that was the marker of women's liberation, right? Was prosecuting these crimes. And it was such a deeply ingrained belief that when I was about to become a public defender, I actually worried more about representing a man charged with misdemeanor domestic abuse than representing someone charged with murder. But then I practiced in a specialized domestic violence court in Washington, D.C., one that feminism built, where prosecutors pursued cases unconditionally, judges were specially trained to take abuse seriously, and protection orders were virtually automatic. Now, taking abuse seriously and protecting people are really unqualified goods. But instead, what I saw was pretty much the same thing as any misdemeanor system. Poor people of color in and out of a revolving door of incarceration. I saw prosecutors proceed with cases against women's wishes, and judges refuse to lift stay-away orders, imposing de facto divorce. I saw immigrant women lamenting that their call for help triggered an unstoppable penal machine that made their spouses, and sometimes them, deportable. So, I start out the book, and I guess I'll read a passage to you that was really a case that I had back in 2000 when I was a public defender that I think was exemplary of many of the specialized domestic violence systems problems. And then after I read the passage, I can talk a little bit more about the rest of the book. So it is the year 2000. I am a junior public defender in Washington, D.C., standing in the early morning courthouse, already buzzing with activity. Uniformed D.C. Metro Police lounge in groups, swapping stories and laughing among the grim-faced, confused defendants and their wide-eyed children. Inscrutable U.S. Marshals with military crew cuts enter courtrooms, accompanied by young, gray-suited prosecutors. I wait for my client Jamal, who at 19 is childlike to me, with his teen Disney show face, neatly done up plaits, and cool Nike kicks. Because of his immature penchant for missing appointments, I gave him my home number. He was the only client who ever got that number. And now, years later, I entertain a hazy memory of his 4 a.m. call to say, "What's up?" Just as I have ephemeral recollections of the bright orange plastic chairs lining the DC Superior Court hallway and the smell of late night sweat in the holding cells. Yes, Jamal sticks out in my mind, but his case is not particularly outrageous or quirky. Jamal's case is notable for its similarity to so many run-of-the-mill domestic violence cases that do not make headlines. I went to court for the Civil Protection Order, or CPO, portion of Jamal's case. Jamal had been arrested 10 days ago after his 18-year-old girlfriend, Brittany, reported that he punched her and threw a plate at her. Prosecutors had lately adopted the tactic of subpoenaing defendants to testify at these quasi-civil hearings without notice to their attorneys. Defendants often attended the hearings unrepresented. If they refused to testify, judges summarily issued the onerous protection orders, which could involve losing one's home and parental rights and expansive stay-away orders. Worse, some defendants took the stand and subjected themselves to rigorous cross-examination without ever consulting an attorney or understanding their right to remain silent. I am here to make sure that does not happen to Jamal. A few minutes before we enter the courtroom, Brittany shuffles up. She's equally cute and colorful, squeezed into stretch jeans with platform flip-flops and yellow shoulder-length braids. She asks if I'm Jamal's attorney, and I reply in the affirmative. She says, "The other lady told me I have to be here, but I didn't want to come." She goes on to explain that she and Jamal live together with their baby in a project called Lincoln Heights, a place, incidentally, where a young man like Jamal is lucky to make it to age 19 without a severe criminal record. Brittany tells me that she only called the police because I was mad and wanted him out of the house. Even if Brittany preferred the police not to arrest, police had to do so under DC's mandatory arrest law. Brittany explains to me that she does not want to pursue charges and will not comply with a no contact order. Then, in a more hushed tone, she asks, "What if I just leave and stay gone? Will they drop the case?" Just as I'm explaining that I can't give her advice, a young woman rushes up and inserts herself between Jamal, Brittany, and me. She's blonde, no more than 24, with a hip haircut and an enormous diamond engagement ring. Domestic violence clinic student, I think. She demands, "What are you doing talking to my victim? And why is your defendant near her? He's violating the no contact order." From the domestic violence advocate's perspective, defense attorneys are extensions of abusive men. They are to intimidate and coerce victims into lying or disappearing. I tell the advocate that Brittany approached us to say she wants to drop the case and stay with Jamal. She replies sarcastically, "I'm sure she told you that." Brittany turns to the woman and protests, "I don't want to be here." And she, pointing to me, said I could leave. Yikes, obstruction of justice crosses my mind. "No," I told her that I couldn't give any advice, I replied defensively. But as you can see, she does not want to pursue this case. The advocate snaps, "We'll see about that. Come on, Brittany, we need to talk," away from them. With that, she leads Brittany away through the sea of humanity gathered in the bustling hall. 10 minutes later, we're all seated at council table. I listen as the judge orders a renewable 1-year civil protection order, including requirements that Jamal leave the apartment and have no contact with Brittany or the baby. Brittany keeps her eyes locked on the table below. The day before Jamal's criminal trial, Brittany calls to say she's not coming. She says she tried to tell the domestic violence lady to drop the case, but could not reach her. True to her word, Brittany's a no-show. Instead of moving to dismiss the case, however, the prosecutor says he's prepared to go forward on hearsay, specifically Brittany's initial excited utterances to the police. Jamal decides not to risk a jail sentence and agrees to a guilty plea and deferred sentencing, which means that if Jamal satisfies his probation conditions and stays out of trouble, the case will be dismissed. If he does not, he will immediately be sentenced on the DV conviction. The judge defers Jamal's sentencing for 9 months, prescribing conditions including 27 domestic violence classes and 10 anger management classes at $8 a pop. A month later, I received notice that Jamal violated the terms of his probation. It turns out Jamal was turned away from several of the mandated classes because he could not pay. We go to court and the judge finds Jamal in violation, enters the DV conviction, and sentences Jamal to 100 days in jail. Jamal serves his time while Brittany struggles to pay for the apartment and baby by herself. They never had complied with the no contact order. The couple eventually lose their eligibility for public housing because of Jamal's conviction. That conviction would be the first of several for Jamal over the next couple of years, none of which were for domestic violence. As for Brittany, last I heard, she was moving from place to place and still with Jamal. So that's a passage from the introduction of the book. So that was pretty exemplary of a lot of the experiences I had. I mean, they were misdemeanors and people might think that the stakes were low, but make no mistake, these were tragic cases. They were cases of economic marginality, of racial discrimination, of social precarity. They were tragedies, right? They were partially feminism's tragedies. But before I practiced, I held to these feminist truths, right? That were just in the ether, that male sexual and intimate violence are the root of patriarchal oppression, which needed to be taken down by incarcerating one bad man at a time. These feminist truths have reigned so supreme that despite progressives' unease with mass incarceration, powerful feminist subgroups have repeatedly championed criminal law. And the puzzling situation today is that those on the left most vocally opposed to racist and authoritarian policing, prison, and punishment are often the most punitive about gender defenses, even minor ones like low-level sexual contact. What about rapists is a conversation stopper when it comes to bail and sentencing reform. And many progressives support not just existing strict gender crime regimes, but propose new laws and broader criminal laws to cover whatever the issue is of the day. So how did feminism suddenly become the legitimator of penalty in an era of declining faith in criminal punishment? How did the feminist anti-violence agenda become inseparable from the pro-prosecution tough on crime position? And how come gender crime gets a carve out from or even veto over criminal justice reform? In answering these questions, I needed to unpack what I call the canonical feminist historical account of gender crime and law. And in this account, right, until it goes kind of like this, until very recently, American law and society were uniquely rape and domestic violence tolerant, and early feminist attempts to regulate rape and DV were feeble and failed. Now, this account prefigures a common sensibility that the natural remedy to gendered harm is tough criminal law. So I went back all the way to the mid-19th century and the birth of American feminism. And what I found was that rape and domestic violence laws were not so much under-enforced as selectively enforced, even over-enforced, depending on the race, class, and status of the people involved. And the early feminists, as feminists today, were rightly concerned about gender violence, and they made philosophical and strategic choices how to address it. Now, these were hard choices, contested choices, and choices under conditions of uncertainty, political oppression, and cultural change. But it becomes clear that feminists opted for criminal law. And these feminist interventions operated within larger social phenomena, from slavery to sex panic. Now, many are familiar with the decades-long lynching epidemic in the South that was enabled by rape law and policy. Well, feminist anti-rape efforts in the late 1800s ran right into that moment, creating tensions between anti-rape activists and anti-lynching activists. And race has always been so intimately tied to what were considered by society to be the worst of worst outrages against women. In 1895, legislators in South Carolina carefully crafted their disenfranchisement rules to cover, quote, Negro crimes, such as wife beating and attempted rape. But notably absent from those disenfranchisement rules were crimes then associated with whites, including murder. On the West Coast, and this is what I borrow heavily from Dean Abrams, notions over Asians' depraved sexuality and the exotic diseases female Chinese immigrants brought melded with feminist concerns over sexual slavery. This culminated in the 1896 Page Act, the very first federal anti-immigration act, which forbid the importation of debauched women and paved the way for the Alien Exclusion Act. And it served as the template for immigration surveillance, detention, and enforcement that still exists today. The complex but often complementary relationship between criminalization and feminist activism was a feature during the second wave of feminism beginning in the late 1960s. So, in several chapters, I address domestic violence, right? And I talk a little bit about that with Jamal. Well, how did that mandatory arrest and prosecution system start? The original battered women's movement in the early 70s was in fact deeply anti-authoritarian. It grew out of late 1960s Vietnam War protest radicalism, right? And shelter feminists within the movement wanted alternative egalitarian societies freed from the government's dirty hands. Anti-poverty feminists saw battering as a product of a cruel welfare system that drove single mothers to abusers. Anti-patriarchy feminists traced abuse to sexist marriage norms and economic inequality. And the feminist proposals didn't have anything to do with criminal law. They included welfare reform, family law changes, and economic reforms, including housewife wages. Researchers outside of feminism traced abuse to social stressors, also rejected criminalization. Many feminists even saw police as the Vietnam War mongering state incarnate. So how was it that by the early 80s, law enforcement was at the center of battered women's activism? Well, a particularly influential group of civil rights lawyers and victims advocates conceptualized battering as a matter of individual violent men enabled by weak law enforcement, right? So I call this group legal feminists in my book. And in 1976, these legal feminists in New York filed the landmark class action suit, Bruno versus Codd, framing the failure of police to arrest for abuse as an equal protection violation. At the time, the New York Police Department allowed police to exercise discretion to mediate to a solution short of arrest. The suit resulted in a new departmental policy favoring mandatory arrest. Now, legal feminists drew on their experiences with clients who told them horror stories about brutal beatings and utter officer indifference. And these were real clients facing real horror. However, they were also a specific subset of battered women. These clients had already resolved to separate, and they pleaded for state intervention. But such was not necessarily true of the entire class of battered women the Bruno lawyers professed to represent. At the time of the litigation, what little research existed indicated that mediation and other non-arrest techniques might more effectively reduce violence. But legal feminists didn't focus on whether arrest worked because they entertained a narrative that established non-arrest as sexist by definition. In this narrative, cops failed to arrest because they are sexists who believe that abuse is no big deal, or worse, sided with the abuser. With non-arrest defined as an exercise of sexism, every arrest became gender justice, regardless of the consequences. Now, that was feminist tale arrest, but there was another tale, the officers. It's true that officers detested taking domestic violence calls and often didn't arrest, but it wasn't all because they were communing with abusers. Now, I don't doubt that some cops had an abundance of empathy for batterers, and some still do. But officer testimony collected in the 1970s tells a different story. Police said they didn't arrest because they feared an arrest would escalate violence and financially harm women. And the most common reason for not arresting was that the victim didn't want it. Within short order, police welcomed mandatory policies, which they saw as, quote, getting them out of the social work business, as one criminologist remarked. And in later years, the police's aversion to touchy-feely mediation became a justification for mandatory arrest. In 1997, Virginia adopted mandatory arrest, and the legislature stated, quote, by placing the burden on the police to decide whether to make the arrest in a DV case, the law asked the officer to serve as a counselor. It is unfair to the officer for him to be required to do more than prevent crime. Now, legal feminists clung to the arrest as best faith despite a growing body of social science that arrest could exacerbate the problem. Initially, activists were emboldened by sociologist Lawrence Sherman's famous 1984 Minneapolis experiment. That study randomly assigned police to arrest, warn, or temporarily relocate suspects and found arrests most deterrent in a 6-month period. However, while feminists and media were lauding the Minneapolis study, larger scale replication studies were already undermining the pro-arrest finding. And by 1992, Sherman possessed enough data to proclaim, quote, mandatory arrest may make as much sense as fighting fire with gasoline. But many feminists responded by doubling down on criminal law. For example, the head of the New York Coalition of Domestic Violence wrote off deterrence, stating, quote, our entire justice system fails to deter the majority of socially marginalized criminals, and therefore it doesn't matter if DV arrest fails to deter. Other studies showed that reforms increase arrests of men, but multiplied arrests of women. It turns out that feminist sexist cocktail had also overlooked that police often use their gender discretion not to arrest women. Still, other studies showed that arrest policies produced stark racial disparate impacts. Sherman's 1989 Milwaukee study found that arresting unemployed Black men for domestic abuse made them more likely to recidivate. Joan Zorza, a prominent DV activist and scholar, argued that the study simply proved that police weren't tough enough. Calling the unemployed Black men, quote, society's failures, Zorza opined that arrest didn't work on Black men because, quote, in subcultures of ghettoized people, where imprisonment is common, a few hours in jail may be seen as only a minor irritation or even a rite of passage. With feminists and the police aligned, the pro-arrest program expanded. And today, the majority of states have these policies. Since I've gone on for about 30 minutes, I think I'll leave it there. But the book then moves on to talk about a similar story about the evolution of rape reform from a non-carceral, sort of intersectional, very left feminist movement into mostly prosecutorial movement. And the final chapters of the book address the penal nature of contemporary feminist movements like campus rape reform, Me Too, and prostitution abolitionism. And through these stories, it really emerges that feminism shaped the modern criminal system, just as participating in the criminal system shaped modern feminism. But in the end, I think the connection between the feminist anti-violence agenda and incarceration is not natural, inevitable, nor even desirable. Still, feminists' important crusade for gender justice often collapsed, and still does often collapse, into simple carceral politics precisely because it was and remains so difficult to imagine a world where criminal law does not rule the roost. But we must imagine it otherwise. And I hope the book will free feminists and policymakers to imagine new approaches to gender violence. As prison abolitionist Nils Christie once said, quote, "The size of the prison population is a result of decisions. We are free to choose." And I hope that feminists make the right choice. And with that, I'm open for questions.
Thank you so much. That was fantastic. And I was really hoping that you would highlight that story from earlier in your career, because it's so moving and so telling. And I just thought it's really, your book does such a wonderful job of crystallizing this intersection. And that case is just such an ideal one. And it speaks to me as well in my work now monitoring misdemeanor bail reform in Harris County, where domestic violence is one of the carve-out offenses where you're not automatically released at booking, and like it's one of the misdemeanors that has a different status in even a landmark bail reform case. So one question that we have from Benjamin Miller is in line with the initial case that you described. Says that how would you advise navigating the situation where a victim doesn't want to press charges, and police and prosecutors are worried that the victim may be just telling them that out of fear? So what would a non-carceral or a less carceral approach to that common situation look like?
That's a great question. And I think that there is truth to that narrative of, amongst the many reasons why a victim of abuse, and even one of extremely injurious abuse, would not want to press charges. One of the reasons could be that, she fears that pressing charges will just make her at greater risk of, an assault once the defendant goes through once her former partner goes through the process of the criminal misdemeanor case. And so what I would say about that is that might be true. But first there are other reasons, right? One might be a distrust of the system. Another one might be that, they're loath to have a child lose their father, or they need him to keep his job for child support or for the family. It could even be love. It could be just a variety of reasons. They're afraid of showing up in court because they have their own open cases, right? But even if it's danger, what I noticed that the response was, getting into the 80s, was based on a narrative of this almost fictional but prototypical case where a woman is begging the police to separate her from the man, and the police are really sexist and they fail to do so, and then she ends up dead, right? And that was kind of the narrative that was driving all these reforms. And it was really something that it did not capture really most, if not pretty much all, domestic violence cases. They just didn't fall within that narrative. But under that narrative, the response to women who were too afraid to cooperate. And that was kind of like every woman, right? A lot of feminist activists thought was to force them to cooperate, right? It wasn't to say, you know, I think actually the battered woman, the victim, she lives with this man. She knows his patterns. She knows when she's in more or less danger. And when she thinks she's in danger, we're going to listen to her, right? It was, well, no, we're going to subpoena her to court. We might even jail her on a material witness warrant, and we're just going to force her to testify. We're going to force her to process this case, or we're going to find a way to go forward with like hearsay evidence, which is hard to do after a 2004 case, but it's still done sometimes. So we're basically going to prosecute this case against her wishes, which I think is the worst thing you can do when somebody is telling you, like, I feel endangered by this process. So, I mean, I think there are a lot of things you can do, you know, for somebody who calls police because they need aid. And when, you know, one of the things that's very nice that a lot of the domestic violence research has gone towards is, instead of just trying to count, you know, incidences of violence and then categorize it as, you know, an epidemic, which already feeds into the program you had in place, which was criminal law. It's like asking battered women, and especially marginalized battered women of color, what do you need? And it's pretty predictable what a lot of women say they need. I need a place to live. I need shelter. And I don't necessarily want institutionalized shelter. I want my own home, right? I want a program like Minnesota's housing, Washington State's Housing First program, right? Like, I want my own money for my own housing. I need child support. I need you to help me resolve my open criminal cases. I need the police not to be surveilling me, right? Like, but the main thing is, you know, maybe I want to stay with him and I want him to stop beating me, right? Like, so, you know, one of the healthy things that's happening is a shift towards having avenues of material aid for the women who are most vulnerable to violence, without that aid necessarily being tied to prosecutors' offices, right? That's the Vawa model, is kind of tying aid to prosecution. So, like, in answer to that question, I don't think that's a false narrative. I think it's an incomplete narrative of the woman too scared, but it took over as the only narrative, and one that was pumped up into death is definitely at stake. And the ascendance of that narrative really led to some, I think, maltreatment of victims by the system, which is why some victim advocates, like I'm thinking of Lee Goodmark at Maryland, who's written a couple books on this, you know, she started out very prosecutorial, and then just through her experience of being a victim advocate, she became a prison abolitionist because of that tendency to mistreat victims.
This is great. So we have a related question from Tessel McKay asking about the ARC and Larry Sherman's work on mandatory arrest, and asking what you make of his more recent findings that DV arrests may not only place the victim at risk, but also increase the perpetrator's risk of being a homicide victim, a non-DV homicide victim in the future.
Yeah, I haven't read that study, but I read the 2015 follow-up on Milwaukee. And that study's finding was fascinating, which was that amongst actually employed, but Black women in Milwaukee, having had their partner, and you know, this was a study where he followed up around 2,000 women, but having had their partner arrested versus warned or temporarily separated, correlated with a 60% increase in the chance that when he followed up in 2015, the victim would be dead. The female victim had already died. And he was shocked to find out that so many of these women victims had died, and not from homicides. They not from domestic homicides, but from all causes. And what he hypothesized was that the experience of going through this arrest process, and there was some, you know, marginal increase in mortality for white women, but especially for Black women who are already under these conditions that, you know, some critical race theorists have called slow death, right? Slow death conditions of racial discrimination, aggression, you know, sexism, all the intersectional discriminations. That what he hypothesized was that arrest was such a stressful factor that it caused, a comorbid stress that on top of all the other stresses really did have a statistically significant death effect on the woman. So in a 20-year follow-up, having had an arrest in your life made you 60% more likely to die. So that study was pretty, wild. I mean, and it was a large scale study. And another study I'm thinking of is Radha Iyengar's 2007 study, which looked at both jurisdictions that did and didn't have mandatory arrest and jurisdictions before and after mandatory domestic violence arrest. And she found mandatory arrest to be significantly correlated with an increase in domestic homicides. And what she hypothesized was that if, a woman, and these are pretty unpredictable, like when domestic violence is going to end up in a domestic homicide, it's like, if you look at the Venn diagram, the world of, domestic violence complaints and potential domestic violence complaints is so big, and the domestic homicide world is so small, it's very hard to predict. But, in those cases where there is going to be that domestic homicide, what she hypothesized is, if the woman calls, or if the person who's being abused calls the police and has a bad experience with an arrest that, they don't agree with and being processed in the system, they're not going to call the police again. And that can really make a difference in those, albeit rare and unpredictable, in those cases where that second call would have made the difference. And the reason she's able to hypothesize this is when she compared it to third-party calls, which mostly happen in child abuse cases, there was no such difference, right? So this felt like what the mandatory arrest was deterring on a large scale was women from calling the police. And that just filtered into, and falling within that pool are going to be some of the women for whom a call itself would have been a life-saving moment. So I'm not familiar with that one, but that's a really interesting one too. And it just goes to kind of like, Brandon is familiar with all of these studies, just the stress of criminal involvement, which is why it's so fascinating that feminist said back in the 90s, like, oh, for people in the hood, it's no big deal to go to jail, right? Like arrest is no big deal. No, these are like major stress factors that contribute to disparate mortality rates and, the slow death of entire marginalized populations. So, this for so long, there had been this idea that, well, if it's not a life offense, it's kind of like, no big deal. But this just shows that these are, they take longer timeframes, but they can be extremely big deals.
I'd be really interested in your thoughts on the question of, what some jurisdictions have done when they've moved away from relying on arrest in domestic violence cases, because, why arrest? The person, especially if it's a misdemeanor case, how long are they going to be in the jail? They're going to be released, and then what's your solution to the problem? But often the alternative solution to the problem is, well, okay, enter a detailed protective order. And often they're kind of standard, right, cookie cutter protective orders that any given jurisdiction will have, and it'll be no contact, don't go to that address, like all the things that, in the story that you told us, were not followed by that couple, and they never had any intention of following it. But, what's the alternative to this cookie cutter? You need to be in separate places, protective order, and for the people involved. And that said, I'm sure, like in some situations, you have the judges thinking, yes, the aggressive thing. I didn't arrest the person. I just issued some conditions to make sure that, and that was the right thing to do. I didn't, this person isn't risking COVID in a jail. They didn't lose their job. They didn't, they're in the community, and these conditions will keep them safe.
Right, and I think that the civil protection order, right, which ends up with a heck of a lot of people in jail, is part of what I think a lot of the activist community would call either the prison industrial complex or the penal archipelago or the, punishment bureaucracy or whatever term, but that encompasses all the carceral adjacent policies too, which this is certainly one, right? Like, so I don't really get into the civil protection order, but there are a lot of larvae articles out there kind of on just how intimately this is tied and how much there is a temptation in decarceration and prison reform work to sell, right? To put forward the purportedly non-criminal, non-carceral alternative as a way of dialing back, some of the pathologies of criminal law. And Victoria Law and Maya Shenwar have a new book out called Prison by Another Name, which looks at a lot of these like monitorings and different things. And the complexity there. And I don't look at it, but I'll say this about civil protection orders. They are mixed up with that criminal punishment system from the beginning. In DC, they would have special rules where they could detain in jail, initially the defendant in a way they wouldn't other defendants in time for them to serve him with this civil protection order. So the criminal arrest was a means of serving this civil protection order. Here in Colorado, you just check the box, and one of those boxes is you can't drink. Like, so they violate the civil protection order if they even drink it all. Like, not even with the part. They're incredibly difficult to get reversed, right? And even if the victim goes up in front of the judge, or the survivor goes up in front of the judge is like, no, under that narrative, I can't have this on my hands, where you guys get back together and then something happens. And then on top of things, the consequences for violating a protection order are usually higher than the consequences for the assault in the first place, right? So there are special provisions making that, a felony, or having special bail rules on it because you violated the court's order. So, there is this tendency to say like, well, this is civil and it doesn't carry all the negative consequences. But these protection orders, they can last years, and they rearrange custody rights. They restrict so many things, like property ownership. They really, it's really amazing that it's the type of thing, just to put a little bit of a race and socioeconomic point on it. If like a middle class, like white family wanted to rearrange all this property and custody and finances and what they could and couldn't do with their life, the litigation would last years for all these consequential things. For the people caught up in this system, it's literally somebody in 2 minutes checking off boxes. And then there's their life for 2 years. So it's not something that I delve into in the book, but I think it is a very important caution that I do get into a little bit in the conclusion, that when we're thinking about non-carceral or less carceral approaches to the problem, there is always this big temptation to offer the alternative to incarceration solution, because people will demand that of you. But sometimes the best thing to do is just less, like literally not the arrest. Stop.
Yeah, I feel like the idea that release is sometimes a good idea is like really hard for people to accept. We've been seeing that in our monitoring work in Houston, where as misdemeanor bookings have plummeted, repeat offending has like stayed the same or declined, and that's really hard for people to compute. The idea that more people having their liberty could also be a good thing for public safety. I'd love to turn to like and you talked about this in your great introductory remarks too, to the sort of the bigger picture of log rolling and politics and how criminal statutes get passed, and the role of feminist arguments and lobbying and organizations in not just the Vawa, but other types of state criminal legislation as well. And it's kind of a big picture. I'd just love to hear your big picture reflection of the feminist role in getting criminal statutes passed over the last couple of decades, which is a huge topic and a big topic in your book. But I'd love to hear you say more about it.
Yeah, thanks so much. It's it's hard because I think that many feminists and even many of the vanguard feminists who tirelessly worked on behalf of women, to protect women, and they had sort of a singular goal of reducing violence against women, which is an amazing singular goal. I think, there are many ways in which that singular goal drown out other more intersectional voices, anti-poverty feminists, Black feminists, and the singular goal might have produced a lot of myopia on the costs of the carceral model, especially in a time of the like incredibly salient tough on crime politics that Bill Stuntz and others and and Brandon have written about in ways that are very compelling. Today say, yeah, we never wanted any of that. We didn't support the drug war or the SORNA sex offender registration and notification system. We didn't support mandatory minimum sentencing. Don't put any of that on our shoulders. And my answer to that is this isn't a book of blame, right? It's not, one of the stories you hear is, feminists were co-opted by prosecutors. Like there are good people and there are bad people, and then the bad people co-opted the good people. And the real story is extremely complicated, and it's a story of producing justice for individual women, even as you exacerbate other problems, and just how strategic choices turned into institutions. So to me, it's diagnostic and it's not blaming. And I think when you look back on the history, it's sort of undeniable the role that the iconic image of vulnerable women. And they also have a racial dimension to it, vulnerable white women and vulnerable to a certain type of man, right? A monstrous man who engages in fast violence, right? The violence of domestic violence, of wife beaters in wife beater tank tops, right? The violence of sexual predator and privileged sexual predator and sexist men, the whistlers, the catcallers. We have these images of the men, we have the images of the women, and that really drives this notion that that we were just talking about, that the solution to society's problems in the name of the vulnerable people of the day, which are often like privileged white women, that these are the solutions to the problem, and we'll throw them in jail. So it's like a perfect melding of these retributive sentiments and these justice sentiments. And I think that it's been wildly effective at helping build and at sustaining the carceral state. So when you look at, for example, Vawa, 1994. So today, and it's funny, and I'm sure Professor Garrett knows this very well, to be teaching things like Vawa and the Central Park Five and the Getz case for, 15 years. And now all of a sudden, like all the students know about it because there have been Netflix documentaries about everything, right? But, today, everybody knows Vawa as the sort of symbolic starting place of mass incarceration, even though there's some empirical question of, really its role. At least symbolically, it symbolized this move of the United States into the ignoble distinction of the most punitive nation on earth. And everybody, leading up to the 2016 election, from Bill Clinton to Biden to Hillary Clinton, did an apology tour for the 1990 Clinton crime bill, right? But Vawa was a big part of that Clinton crime bill, and nobody's doing an apology tour for Vawa. And in fact, when you go back, Bill Clinton said, and it was also called the Biden crime bill, by the way, but Bill Clinton said, Vawa is a particular genius of my crime proposal because it melds, our much needed tough on crime, very popular, with concern for women. So, for example, Bernie Sanders came to the floor of the House, he was then in the House, and basically stated, this is horrible. We can either electrocute our way to justice, or we could give people jobs. We can incarcerate, or we can give people education. I'm completely opposed to this model. And yet he voted for it. And what he said was he voted for, yes, for the assault weapons ban, but he said this, quote, to protect women, right? So that, melding of general crime control politics and the symbolic weight, both on the right and left, of women victims, I think has been very important. And it's why there's carve-outs now from bail reforms and sentencing reforms for domestic violence. In fact, a compromise for the First Step Act was new mandatory minimums for domestic violence crimes. So I do think that, operating under this assumption that you can get really tough on a crime that reflects gender inequality without adding to the rest of racialized, class, and gendered mass incarceration, I don't think history bears that out. And I think that it's something that feminists should keep in mind when they're looking at a problem that's a pressing social problem, to fight that instinct to think, criminal law, because we're going to be siloed in this way, because it's never proven to be true.
That was really, really helpful and interesting. I don't see any questions in the chat right now. I'm also thinking, based on your mention of the Central Park case, and there's so many classic criminal procedure cases that involve Black male defendants and white female victims. And that's sort of the history of the modern death penalty is, rape prosecutions in the South. So many of the exonerations, like in the Central Park case, have also involved Black defendants, white female victims. And the kind of, do you think that people, you talk a little bit about like millennial feminism versus earlier generations of feminism. Do you think the public is more aware of the consequences of a rush to judgment based on stereotypes in criminal cases that raise issues both of race and gender and punishment? Or do you think that there are still plenty of instances of media stereotyping that can contribute to exactly that kind of rush to judgment? This is sort of like a cultural question, I guess. Has culture shifted, or do you think we would still have the same frenzy around a Central Park jogger today that we did in 1989?
It's such a tough issue, right? Because random violence is something that just inspires so much fear in people, right? It is how terrorism basically works, right? It's not that you have high statistical probabilities of, these terrible things happening, but the randomness of them, or if you can find a pattern that relates to some characteristic you have, just inspires so much fear. So for example, like being Asian American right now, what you see around you are these attacks on Asian Americans that are, they're really horrific and awful, but still, like statistically, just because you're Asian American, you're probably extremely unlikely to get attacked, but you can't tell that to people who are really scared, right? And in this moment of being really scared, people have a tendency to go to their most carceral instincts, their most carceral impulses. And that's just a really hard thing to pick through. So I'm thinking about the conversation right now with, Asian Americans and hate crimes. And, when you look at a lot of the crimes against Asian Americans right now, they have various differing aspects to them that might or might not be well served by just ratcheting up punishment for assaults. It's interesting, but this moment of Asian American hate crimes is now being tapped by a very tough on crime contingent to say that the man who attacked brutally attacked the woman in New York City had recently been granted probation on for murdering his mother after spending 17 years, and he was pretty young, and now we should do away with probation. So this is just the natural pattern of things, is that when there are moments of galvanization, and I'm not a social movements expert by any means, but there are moments of galvanization that make people think of deeper structural issues. So like right now we're thinking about narratives of Asian Americans and how political narratives of the exotic diseases they bring, which is hasn't apparently changed since the 1800s. Like it's that same racist narrative, how the racist narratives might play, how model minority tropes might play, how the marginalization of recent immigrants from Asia might have played in the Atlanta massacres. Like we're thinking of all these things, but at the same time, there is that impulse just to blame it all on the horrendous individual who made the headlines. And I think feminism is no different, right? So on the one hand, you have these Black Lives Matter protests that, predated the Floyd trial and really affected young left feminists on campus to go out and protest and be very cognizant of racialized mass incarceration and policing. At the same time, then, whenever Harvey Weinstein was in the news, it was like, I really want to see him kind of tortured and killed, right? Like he got 23 years, we should celebrate. That an ill man in his 60s, yeah, he did terrible things, but what we should celebrate this moment is a 23-year jail sentence for somebody who's ill and old. So I think it's very hard to constantly be consistent with structural analyses of things that are so visceral. But I think we have to do it because mass incarceration was built one visceral crime case at a time, right? That's the pathological politics of criminal law. And I don't think being a progressive makes you immune to the same kind of tough on crime, victims' rights reasoning that led to things like Megan's Law and the SORNA, which is just a disastrous policy, which led to 3 strikes, which are horrible policies. I think there was more to it, but it had some of the same appeal that can appeal on both sides of the political aisle. And so one of the prescriptions for feminists is to always keep your eye on the structural and understand that, policy changes made in the name of getting at spectacular defendants, especially powerful, rich defendants who just make people so mad because they seem so immune to punishment. So we, ratchet up the punishment and still some of the same people are immune. I'm thinking of one in particular, right? Like some of the same powerful people are immune. And yet now we've given prosecutors so much power, and who do they use their power against? The usual suspects, right? The usual suspects are the ones caught up in the system built for the people who are likely to remain immune for reasons that have nothing to do with criminal law, right? For reasons that have to do with, I don't know, like being the president or something, right? So it's just something I urge feminists to think about when they really want to take down their preferred bad men, who tend not to be like Black men anymore, like bestial Black men, but who tend to be like powerful, white men, that the system was built, the system of rape punishments and the whole like sort of origin of it was built on an image of post-Civil War self-bestial Black man. And when you add to it, it's not going to be easy to get that carve out. And you might be adding to it for the Brock Turners of the world, which is a whole other story. But, that's not who's probably going to be affected by a lot of these changes.
Maybe we have time for one more question. I'm looking to see if there's anything new in the chat. I don't see anything right now. Well, one last quick question on the topic of the structural. It does seem like there's a theme that you've briefly mentioned. I wonder if you want to focus on it for just a second. In terms of the structural, one big theme is housing, right? And that locking people up doesn't change the underlying lack of housing options, especially for poor women, which may make lots of different types of criminal enforcement cause their housing to become more stable, or it may be the reason why they don't have the options that they need, and locking up an abuser up is not going to change that. Do you feel like there has been progress in recent years towards addressing some of these economic vulnerabilities that a carceral approach doesn't address?
You know, what I've noticed, at least in some of the discussions I've been having since the book came out, which was last summer, is a sort of willingness on the side of young feminists to think outside of the box about how to be a feminist in the space of criminal law. So for example, there are organizations that have been around forever, like Incite, you know, organizations like Black and Pink, or Survived and Punished, right? Survived and Punished is one that really melds feminism and anti-incarceration because they concentrate on incarcerated women. And, you know, if you really want to make sure that somebody never has stable housing, put them in prison. That will pretty much guarantee, you know, that they will be in and out of, at the very least, precarious housing situations. So I think shelter is so key. You know, you still have a fairly robust prostitution, you know, neo-abolitionist movement amongst feminists. And they really want to use the criminal cudgel. And it really is a cudgel, like these anti-trafficking laws. They really are just incredibly broad. I mean, they are so broad, and just the sentences are so very high, and they keep some of the more organized indoor sex work really, really on the edge, right? Where they can't, for example, call the police if there's some problem customer who looks like they're, you know, they're trouble. They can't call the police, because if you're the one who receives money, you can get, you know, you can run afoul of the trafficking laws. So through this cudgel, they want to get women out of the commercial sex business, because they think, you know, for right, and I think, you know, some wrong reasons, that it's like the worst thing that can happen to a woman, that you can find yourself in the underground sex market. But really what would get people out of that market would be to give them housing, right? Like, actually, when you ask marginalized sex workers, they say, yes, shelter would go a long way for me to, quote, like, get my life together. Right? And that's like the opposite of what this model does. So I think there are so many opportunities for feminists interested in violence against women, or interested in the intersection of women's rights and criminal law, to do something other than what, at least, you know, since I've been a lawyer in the late 90s, has been, it seems like, the preferred feminist criminal law route, which has been become a sex crimes prosecutor, become a DV prosecutor. That's what you do if you're a feminist interested in criminal law. I'm seeing like a refreshing change. And those who do want to be prosecutors have this sense of maybe reforming from within, or being a progressive prosecutor. So there's a real sea change. And I think a lot of that had to do with just, you know, watching that horrific video of George Floyd being asphyxiated to death, was just, you know, woke people up to say, this is this system. This is not serve and protect. This is a system that they built, but we also built, one decision at a time, right? Each decision at a time. And we don't accept that anymore. The thing that worries me is that, you know, movements come and go, and then the next thing changes. And I just really hope that that the Black Lives Matter protests, 25 million strong, of the summer, that united the world for a moment, that doesn't get lost in just the billions of other issues, but remains something that at least a generation of young lawyers and young feminist lawyers have staying with them, at least for a while.
Thank you so much. That's a perfect and inspiring way to end. And I wish we didn't have to end. This was so fantastic. We can't thank you enough for joining us and for sharing your book with us. And I hope that lots of the people at this event or watching the video later, if you haven't already, read the Feminist War on Crime, and stay a part of these conversations. I saw a wonderful note in the chat that we need to stay in touch on these issues and think about what we can do as feminists and what we can do to rethink carceral approaches towards these underlying problems. Thank you all so much.
Thank you so much for having me. This was great, and it was wonderful to see you.
It's great to see you too. Thank you.
Okay, take care, everyone.